This is part 2 of a series on judicial precedent. We'll talk briefly about the history of judicial precedent and then talk about some specific laws you will need to know. The common law became a practice in English courts soon after 1066. That's the year 1066, when England was conquered by William the Conqueror. Courts began keeping and sharing records of their decisions with the goal of unifying, that is, using the same principles of law all across England. The courts would solve new problems based on the solution of similar past problems. Judges became required to follow the decisions of an earlier judge and to adopt the earlier judge's interpretation of the law and apply the same principles if the facts of the new case were similar enough to the facts of the old case. The courts began to publish their decisions in books called yearbooks, which were studied and debated by judges and lawyers during meetings. Lawyers is not the word used in England, but you get the idea. The unification did not happen quickly. In fact, it took hundreds of years. For a long time period, England had two kinds of courts which operated independently of each other, except that appeals from those courts usually went to the same lord or group of lords. One set of courts is often called courts of equity, and the other is often called common law courts. Common law courts. But do not let the names fool you. Courts of equity also followed judicial precedent. The difference between the two courts was really in the kind of relief or remedies they could give. So let's briefly discuss the law of remedies. Remedies are generally what the winner receives when he or she wins a lawsuit. Remedies can be money, but they can also be other things such as a protective order, a division of property, and child custody, to name a few. Before a person files a lawsuit, the person needs to have an idea what remedy they can expect or what remedy they want. The courts of equity could not award money. They could only award orders for specific acts. If a person needed a court order to keep his neighbor's cows off his pasture, the person needed to go to a court of equity. If a person needed his cattle returned, the person needed to go to a court of equity. But if the person needed money, then the person needed to go to a common law court. In America, there is no such difference. All courts have the power to award money or award what's called injunctive relief, which is an order saying do or don't do a specific thing. But I mention the history for two reasons. One, in case you hear something about equity is another source of law, or equity is different from the common law, because neither of those is true in America today. And two, so you understand how much of the law is controlled by judicial precedent. Every dispute about land, livestock, money, contracts, ships, produce, raw materials, and finished goods, and any other imaginable dispute went through the English courts, which created law, or modified law, as necessary to achieve a just and legal result. In England, the courts were the primary source of law for centuries, until England developed a democratic legislature. The king or queen could order things and issue warrants and issue charters, but the king or queen could never keep up with all of the judicial decisions being made across the country. The common law of England was adopted by the United States at the time it broke away from England, so the United States adopted several important concepts that were part of English law. And the common law of England and the United States was adopted by Texas when it became independent from Mexico. Today there are several important concepts in law which were created by courts while practicing judicial precedent. One of the most common concepts is a claim for negligence. That is, the ability to sue and recover money for negligence. The elements of negligence are 1. Duty, 2. Breach, 3. Cause, and 4. Harm. A video on negligence could take hours, so we will only briefly discuss it here. The general idea is that a person can be liable for damage the person causes if the person fails to behave reasonably. But there are important limits to the idea, and the first limit is the requirement of duty. A person will not be liable if the person had no duty to the injured person or group of people. For example, a random person standing on a beach has no legal duty to rescue a drowning swimmer. They might have a moral duty, but generally there is no legal duty. If a random person walking through a playground notices a bolt is missing from a swing set, they have no duty to contact maintenance and no duty to warn children who might use the swing. So a child cannot win a bunch of money from the random person if the child falls from the swing set and breaks their arm. But if you change the facts, you might create a duty. For example, if the person on the beach is no longer random, but if the person on the beach is the lifeguard on duty, then the person might have a duty to save a drowning swimmer. And if the person in the playground is no longer random, but if the person is someone who intentionally removed the bolt, then the person might have a duty to replace the bolt or warn the children. Cause means proximate cause or foreseeable cause. A person is liable for damages that are reasonably foreseeable. People are not required to be fortune tellers. People are not responsible for the butterfly effect of their actions. Harm certainly means damaged property, medical bills, and the like. Harm does not mean insulted, embarrassed, frightened, offended, or confused unless it rises to a certain level, such as post-traumatic stress disorder. Breach means failure to act like a reasonable person. A reasonable person usually drives the speed limit, stops for stop signs, keeps in a restaurant or a grocery store, keeps floors clean and dry, or at a house puts fences around swimming pools. A reasonable person does not horse around with power tools, and so on. And here we touch upon another concept from the common law that is prevalent in American law today, and that is the concept of the reasonable person. But first, let's make sure you understand how prevalent negligence law is. Every time somebody files a lawsuit for a car collision, a plane crash, a slip and fall at a store, a playground injury, a medical injury, food poisoning at a restaurant, a house fire, and 1,000 other things, they all make a claim of negligence. It happens thousands upon thousands of times every day in courthouses all across the United States. It happens so much you can buy insurance to protect against it, and all car drivers are required to buy that insurance. Reasonable person, and its variants, is a concept with application in negligence law, contract law, products liability law, and jury instructions, and probably others. Variants include reasonable landlord, reasonable juror, reasonable consumer, reasonably prudent driver, and objective observer. The idea of a reasonable person for most people is a person of average intelligence, but lawyers and judges try to avoid the word average. Among other characteristics, a reasonable person is objective, which means that the person is not biased, prejudiced, or personally involved. Objective is a word students need to understand. It usually is the opposite of subjective. Subjective refers to the view of a person actually in the story, so to speak, while objective refers to a person viewing the story from the outside. This is an important concept that confuses some people, so I will give 3 examples. First, Little Red Riding Hood. Little Red Riding Hood might see the wolf in grandmother's clothing, but not realize it's a wolf. In the story, it takes her a while to figure it out. From the view of Little Red Riding Hood, it appears to be grandmother at first, until she thinks or begins to think about it harder. But most people reading the story can tell right away that it is not grandmother. Little Red Riding Hood is in the story and takes some time to see the truth, but the reader is outside the story and can see the truth more easily. Some young children have irrational fears, such as monsters under the bed, sharks in the swimming pool, and being flushed down the toilet. A child with an irrational fear is subjectively fearful because they are honestly afraid. They are not faking it. But the fear is objectively unreasonable. A reasonable adult looking at the pool, the bed, or the toilet knows the shark, the monster, and the accidental flushing of a person is never going to happen. Last example. A person might offer to sell a shiny new pickup for $1. They might honestly be serious, in which case their offer to sell is subjectively serious. But a stranger will be objective and probably think that the offer is a joke. So the law wants every driver to be reasonable. The law wants every mechanic, pilot, and dispatcher to be reasonable and to do their job in a reasonable fashion. The law wants every offer for a contract to be objectively serious, which means a reasonable person would think it is a serious offer. The law wants every juror to see and judge the evidence objectively and reasonably. Each juror is allowed to make reasonable conclusions based on the evidence, and a verdict will be ignored if it is not reasonable. If a person claims self-defense, the law asks, would a reasonable person have felt the need to defend themselves? Every manufacturer must anticipate reasonable uses of their product and make the product safe for every reasonable use. Every negligent person must pay for damage that was reasonably foreseeable. Every person who breaches a contract must pay for losses that were reasonably foreseeable. And this brings us to two more concepts in the common law: compensatory damages and consequential damages. We can spend more time on remedies, but for now let's focus on making the injured person whole. When a person wins a lawsuit, the law generally tries to put them back to where they would have been. For example, if somebody's car is damaged by another person, the law tries to give the car owner enough to buy a car just like it, or enough money to fix the car that was damaged. Another example, if a person breaches a contract, the law tries to give the victim enough money to make it as if the contract was never breached. This can be very tricky in some situations, such as situations involving pain and mental anguish. Okay, now let's move on to one of the most important common law decisions in the United States, and maybe the most important ever. It was a case called Marbury versus Madison in 1803. In that case, the two questions were decided were first, whether a law passed by Congress or any law passed by any legislature could contradict the United States Constitution. Second, who can decide whether a law violates the United States Constitution? The Supreme Court decided no law can contradict the U.S. Constitution and decided that courts have the power to judge every law by the Constitution. These two principles might seem obvious to people today, but in 1803 there was some serious debate about the second, that is, whether the courts could ignore laws from Congress because the laws violated the Constitution. The Constitution did not say courts could do that, but the Supreme Court said it was kind of assumed by the Constitution because the Constitution really could not work any other way. The ruling was made in 1803, but the court did not declare another law unconstitutional until 54 years later. By that time, most people did not want to seriously argue about the principle anymore. It was set law, and it has been set law ever since. Let's end this video by discussing how judicial precedent works between courts in different jurisdictions and at different levels. To start, it should be obvious that, for example, the Supreme Court of Kansas is not going to have any control over Texas laws. Even if the Kansas Supreme Court, for some weird reason, did declare a Texas law violated the Texas Constitution, Texas courts would have the power to ignore that decision from the Kansas Supreme Court. What about the United States Supreme Court? Could the U.S. Supreme Court decide that a Texas law violates the Texas Constitution? The answer is no. The U.S. Supreme Court does not have the final say on what does or does not violate the Texas Constitution. In fact, the U.S. Supreme Court is required to follow or enforce all Texas laws if Texas has jurisdiction, unless the Texas law violates the U.S. Constitution or contradicts a U.S. law. Generally, laws from the U.S. are supposed to trump laws from the states, but the state laws are supposed to be honored whenever possible. Sometimes, when trying to decide what's the best thing to do, courts in different states will look to each other for guidance, but they are not required to follow judicial decisions from outside their state. But what about courts on equal footing within Texas? For example, the courts of appeals. As you should be learning, Texas has 14 courts of appeals besides the Texas Supreme Court and the Texas Court of Criminal Appeals. The 14 courts of appeals are above trial courts and below the highest two courts. Are they required to follow each other's decisions? The answer is no. If two or more of those courts of appeals begin to apply different principles, then it is generally up to the Texas Supreme Court or the Court of Criminal Appeals to make a decision and choose a principle that should be followed by all. And then, once the Texas Supreme Court or the Court of Criminal Appeals makes the choice, then all 14 of the courts of appeals should follow. Let's focus on the 10th Court of Appeals, for example. The 10th Court of Appeals has a courtroom in Waco. The 10th Court of Appeals has been given a geographic territory that includes 18 counties. Its decisions are supposed to be followed in those 18 counties. But its decisions may or may not be followed in other counties besides those 18. In sum, you need to know that the U.S. Supreme Court has the last word on the U.S. Constitution and the U.S. laws. The Texas Supreme Court has the last word in Texas civil cases concerning the Texas Constitution and Texas civil laws. And the Texas Court of Criminal Appeals has the last word in Texas concerning criminal cases, the Texas Constitution on criminal cases, and Texas criminal laws.